Sure. Yeah, no, please.
Great.
Sinead's trying to sing.
Sorry.
Don't worry. It feels really weird. I've never had this kind of mic. No, they're not.
Oh, really?
Wait, I've never had this one. It feels really weird.
Oh, no.
How was that conversation? That's what Sinead was trying to signal.
That silence just
Yes. Yeah. You'd be amazed at the number of variations of my surname. So it's a really good close approximation.
No problem.
Okay, so now that we're all assembled, I think we'll start this session, which is looking at the global context for abortion rights in 2017. And we're very fortunate to have Louise Melling, Sinead Kennedy, and Les Allamby to present in respect to this topic, and also to have, I think, contribution in the discussion also from Francis Radai, whom you heard from earlier on. So each of the speakers have 20 minutes, and I think we're going to start with Louise Melling. Louise, as you might know, is the Deputy Legal Director at the ACLU, the American Civil Liberties Union, and the Director of its Centre for Liberty, which encompasses the ACLU's work on reproductive freedom, women's rights, lesbian, gay, bisexual and transgender rights, freedom of religion and belief and disability rights. So she effectively leads, as I understand it, the work of the ACLU to address the intersection of religious freedom and equal treatment, among other issues. And prior to becoming Deputy Legal Director, Louise was Director of the ACLU Reproductive Freedom Project, where she oversaw nationwide litigation, communications research, public education campaigns, and advocacy efforts in state legislatures. So pretty busy overall. I wonder how much she's going to be able to say in 20 minutes, or if we should perhaps extend the time. But let's start with that at least. And Louise, I think, do you want to address us from the stand, or are you happy to sit?
I'm happy to sit.
Great.
That works for people.
Yeah.
So thank you so much. A shout out to the ICCL for convening us. Thank you to the speakers before, from whom I've learned so much. And thank you to every activist in the room who's working to make life better for women throughout the globe. I'm here from the United States, where abortion is legal, where the federal Constitution has protected it since 1973. But as you all know, it is hotly contested. It is hotly contested not just in this administration, but really pretty hotly contested in different degrees for 40 plus years now. So I want to talk a little bit about what that contest looks like, and then from where I sit, I just wanted to offer a few reflections about, like, if I were starting from scratch, what I might think about doing or whatever, what I wonder whether we did it right. And of course, I'm coming from the United States, which I sometimes feel is just a parochial beast, and don't know whether the lessons, extend out further. And also, you could say, why would we listen to her lessons? Because how's it going over there? But nonetheless, I'll offer some views. So first of all, it was a decision of the United States Supreme Court. It wasn't legislation. It was the United States Supreme Court decision, 1973, that recognized that the federal Constitution protects the right of a woman to decide to end her pregnancy if that's what she wishes. Decided on privacy grounds. It's a decision between a woman and her doctor. Doctor featured big in the decision, as opposed to a decision for the government to make. The court reasoned that way, even though the decision arose sort of in the heat and passion of the women's rights movement at that time. The court said no state can ban abortion before viability. Left some room for some regulation before viability, and that room for regulation before viability has now been, that invitation has been extended. Before I talk about that extension, I'll just say, after viability, the court said you still can't ban abortion if it's necessary for a woman's health or life. The invitation was even more robustly made by the Supreme Court in 1992, saying that states can regulate abortion in the interest of protecting fetal life or in the interest of a woman's health, as long as it doesn't constitute an undue burden on a woman's right, an undefined term, creating for decades of litigation by people like me and other people at the ACLU, the Center for Reproductive Rights, and others. That invitation, states are just jumping right up, stepping up to that. And so here's the kind of things we see, many of which you already know about, I think. There's the regulation of facilities. You heard a lot about that probably even in your countries in the context of Texas. For example, regulations to make facilities that provide abortions look like hospitals. Read, make it impossible for them to stay open, so they have to close, and justify this in the name of women's health. Lots of regulations of what I'll say, women. I mean, I realize these are all regulations of women, but regulations of the following sort: you have to listen to a state-mandated script in person, then you have to come back in person some period of time later, 24, increasingly 48, now we're seeing 72 hours later. That's true no matter how firm your conviction was. That's true no matter how inconvenient it is for you. Increasing rules that you must have an ultrasound and that the doctor has to describe the ultrasound to you or show it to you or offer to show it to you or have you listen to the heartbeat. One state, the requirement is that the doctor has to tell you that abortion kills a unique living human being. Regulations designed to discourage, shame, punish, right? There are also another category, I'll say, that we're seeing to ban abortions for reasons of fetal anomaly, or in particular to ban abortions for reasons of Down syndrome, as a way to try to create a divide between different movements in the United States. Bans on race-selected abortions. We didn't know there are no race selection abortions. That again is meant to tap into a campaign by some saying that the most dangerous place for an African-American child in America is in its mother's womb, that abortion is black genocide, and just to give you a flavor of what it's like in the United States. Bans on sex selection abortions, which I view as like trying to buy into stereotypes based on immigration and in particular stereotyping of Asian Americans and casting doubt on abortions in different communities. So that's, we can keep going. But that's kind of a flavor of what happens. We sue, we challenge, some things we strike, some things stick. The things that stick aren't usually the things that are the most dramatic. The most dramatic we can take down. The things that stick, so we think of them kind of as one brick. So one brick may not be terrible, not good, but not terrible. But if you have one brick put in 2010, a couple more put in 2011, and you keep going, all of a sudden you have a wall that a woman must jump. And as you can well imagine, as we heard from the discussion before, the wall is the greatest, the highest when it comes to access for poor women and rural women in America, as in other places. I think that the restrictions, they do many things, obviously, right? They obstruct. They punish you for having sex and not conforming to a stereotype. They shame women, they shame doctors. But what they also do is keep the conversation hot, right? Every single one of these restrictions serves from those who are putting it forward as a way of saying, abortion, it's not that safe. We have to step forward for women. Abortion, immoral, we have to protect. We have to make sure you really know what it is because it's such a major decision. And we don't trust that you know that. That's why we're going to make you go through it. It is a way that the contest keeps going. So the decision definitely didn't shut down the conversation in the States in that manner. So I'm just going to talk about what I think some of the lessons are when I kind of look at this situation. The first, I think, is pretty obvious from what I've just said, which is don't be sanguine about a win. Our getting the Supreme Court decision, I was, rural and young, so didn't really celebrate it. We didn't have a TV. I don't really know how I would have learned. I guess there were papers. I read the comics. But don't be sanguine about a win. This is an incredibly important win that was, celebrated. But I assume, right, the activism was to get this win. Like we talk about, repealing or getting a win, as opposed to sort of bracing ourselves that the fight continues even after that, and that you have to stay in. And you have to stay in even when the fights are sort of, I'll just say, less obvious, or sometimes I say in the world where there's so many challenges, is the waiting period the place where you put your energy. A waiting period doesn't look like a ban. But the other side, especially after that win, is all the more motivated. They were in a struggle as well, and now there's a loss. And if you think about the loss, particularly if you're somebody who believes abortion is murder, then there's real reason to show up. So there's reason for people to show up, and in the United States, people who are really committed to stop abortion are very motivated. And now the political dynamic is such that the political forces, and in particular now it's really the Republican Party. I'm from a nonpartisan organization. I'm not saying this is a partisan thing, but more as a factual matter about what it looks like in America, which is that the Republican Party knows that this is a motivator, knows that this gets people to the polls, and therefore uses this as an issue. We saw that, I think, in the last presidential election. I don't think that Donald Trump personally has a stake in whether abortion is legal or not. That's not what his prior history suggested. But he sat on 60 Minutes and said he would appoint justices who would work toward the reversal of Roe, because he knew that that would help shore up a base that was not necessarily his, and it would drive people to the polls. Some say that vacant seat on the Supreme Court is what decided the polls because of that animation. So anticipate that this battle will go on, and I think even build it into thinking about how you motivate and engage people so that people are in it as much as people can be for the long fight, not just for the big win, but to keep going. The second, at least as I think about it in the States, is to keep the values conversation going. There's been a lot of values conversation here today. It's pretty refreshing. Because I think, at least for us, 4 decades in, there's two different kinds of, there's a kind of shorthand. One of my friends who moved to the States recently said, oh, so it's pro-life versus choice. Like, you guys, you didn't pick a good word. But it's come down to that kind of shorthand, as opposed to that we support the right to women's health. We support agency about our health, agency about our family, agency about how we survive, agency just about having a shot to survive, or a shot to finish school, or a shot to take care of our kids. And then translating that value, if I said to my siblings, like, oh, this is about agency, they'd be like, what? Or back to somebody made the point, forgive me, but I think it was you. Figuring out how also to talk about that in a way that is understandable and meaningful to people. But the value, we're all here because we value what this means to people's lives. But I think we sometimes lapse even publicly into shorthand in a way that doesn't remind people. At the time in the States when Roe was decided, I think it was clear that morality was on our side in the same way that so many of you have discussed. When you have women literally dying, when you have women winding up sterilized, when you have women otherwise suffering tremendous health consequences, that people can see, that people understand because of the illegality of abortion, people step up. But then once abortion becomes legal in our country, and you don't see the harm the same way. Harm is still happening, but you don't see it in the same way. It becomes all the more important, I think, to continue to articulate. And don't assume people have memory, not in the States, right? In terms of like historical memory of why this mattered. I think, so third is just, I have to remind myself to do this a lot. Remember what you're asking of people. Like, we want to gin up activists. We want people to have more people wholeheartedly believe in the importance of access to abortion for people's lives. But there's a whole bunch of people, and there was a reference again earlier, who would never choose abortion for themselves, might even say in some manner that they're opposed to abortion, but would support the right for other people. I wouldn't do it for myself, but I don't think we should get in the way of somebody else. So how do we make sure that we temper our language so that we talk to different people, or that we talk in a way that can open up ears to people? So the difference between saying, I'm here because I think abortion is a human right. Some people who believe us will go along with that, but other people who haven't yet really thought about it may think that's too hard a conclusion. So sometimes this is based on like clinical psychologists and other people sort of talking about one way to let people hear you is to say, we may not all agree about abortion, but we surely can agree, that the government shouldn't ban it, or that the government shouldn't behave in a way that hurts the chance for women to control their lives or to protect our safety. So that people who may not yet hear, or might be at least neutral, can at least hear and come into the conversation. I look back and I also think, what are we asking of the government in some way? Are we asking the government, when we have these campaigns, simply to lift the ban? Are we also imagining a future, this may be very American, where abortion could actually become part of the healthcare system, abortion where there would be more efforts made by the government to enable women to access abortion so that it's not only a negative right, but there's a positive dimension. The States is not, we are not the model for anybody in terms of positive assistance, particularly around healthcare. But, there's a robust debate in the States about, because the right was argued and one is a privacy right, did we limit people's imagination? I frankly think that you can call it a duck, you can call it privacy, you can call it equal protection, you can call it anything you want. And in the States, we're seeing it contested. It's not the name, but that may not be true in your countries in terms of thinking about, like, what's the real vision you want? And even at the beginning, can you think about that vision and insert it into how you run your campaigns in some manner, if that makes sense? Don't be the frog in the water that keeps getting heated up, in some sense, or watch those things that look small and how they add up. In the States, we very soon after Roe had many of the states, pass laws that said that institutions and individuals didn't have to provide abortion services if they had moral or religious objections. It was very fast that came on, and it came on, I think maybe everybody, first of all, very hard to oppose in the States, and also the win was still there. Very soon around the same time, the federal government stripped abortion out of the Medicaid program. I think there was like a 3-year period where abortion was in the Medicaid program. Medicaid is the government insurance program for the poor. Soon thereafter, we had some states ban abortions in public hospitals. Those things have all stuck. There's no abortion access in any government insurance program. We went from you don't have to do it if you think it's immoral, to the government dollars don't have to support it. In fact, we can favor childbirth, to then a subsequent Supreme Court decision that said the government can use its power to favor, not even just with money, but otherwise to favor childbirth. So the backdrop, what I call like the wallpaper of our culture, has the US government stepping away from something that's a constitutional right, the US government stepping away from something that even the Supreme Court acknowledges is necessary for women's health. It's, you have a message that it's immoral, I think, or at minimum, icky, right? The government will distance itself, public hospitals can distance itself, all insurance can distance itself, doctors can distance themselves. And I think that adds up to contribute to the backdrop in which we find ourselves in such a contested battle. Each one of those things we recognize was bad, but I'm not so sure we recognized about how bad they all were when they got added up. The other is, and I'll just sort of end with a final, which is to put women in the picture. And I think if Fiona, I heard you definitely talking about pregnant people, and I'm mindful of the difference between pregnant people and talking about women. In the States, I think most of these measures are targeted at women, so I'm prepared to talk about women. But I've done it here today, and I think a lot of us have done it. We talk about abortion. Abortion is the thing that's most controversial, right? I think that's probably a word that evokes the image of the procedure, but we don't put the person in the picture. I'm not stepping away from the word abortion, I'm asking to add a person. We don't talk about how women need abortions, about how this matters for women. I mean, we do, but our shorthand often leaves out the person. And I think when we talk about the people, so I think that matters. I'm watching the difference between what happens with reproductive rights in America and what happens with LGBT in America. We have a case before the Supreme Court that people talk about as the cake case, but most people don't really talk about it as the cake case. They talk about it as the couple being turned away because they wanted a cake, the couple being gay. People don't talk about the woman being turned away at the hospital because of what she wanted was an abortion. We don't talk about women being turned away from the doctor in the same kind of frame. We talk about the hospital not providing abortions. We've left out the woman, and at least in the States, the frame of discrimination, people may not all agree on all the details, but they know they're not supposed to support discrimination. So it changes the conversation. So that's one way in which putting the woman in, I think, is really important. I think putting all women in. We sometimes talk in the office like how important it is not to just talk about what politics think of as the good girls, the women who didn't want sex or who wanted to continue the pregnancy. Those women are real. Those women need to be talked about, but that is not the full story. The full story is like the full room and the many, many different reasons why. And if we're afraid to talk about the full diversity of people and why we seek abortions and why it matters to us in different ways in our lives, we risk letting some women get stigmatized and leaving them more vulnerable to be cut out. So it all goes back to the basic proposition that we've been talking about all day. What our laws say about abortion says a lot about what we say about women. It says a lot about whether we think that women are entitled to be sexual beings. It says a lot about whether we think women are entitled to decide not to pick up the mantle of motherhood at particular points in their lives or ever. It says a lot about whether we think we can trust women to think, trust women to be compassionate, trust women to make fundamental ethical decisions. It says a lot about whether we just respect women and think that we can think and be. So thank you. Good luck with your fights. May they go better.
Thank you, Louise, and you certainly did manage to squeeze a lot into those 20 minutes. And I think it's a lot of what you've said certainly resonates in both the global context, but also this context. And I have so much more I want to say about that, but I'm not going to, because I'm going to restrain myself at this point and introduce Sinead Kennedy, who is Secretary of the Coalition to Repeal the Eighth Amendment. That is a coalition many of you may know, but it's basically a coalition of 100 organizations that campaigns to repeal the Eighth Amendment to protect and respect women's lives, health and choices. And Sinead also teaches in the English department at Maynooth University. And she's written widely on cultural politics and feminism. Again, many of us are familiar with her work, the Abortion Papers Volume 2, buy it if you haven't already. And she's also completing a book currently on the Eighth Amendment. Sinead, I think it says in the bio that she's also been active for many years in pro-choice politics. I think she's being demure. She's done and continues to do Trojan work in terms of her activism in that area, and we're all very grateful for that. So, Sinead, 20 minutes.
Okay, thanks very much, Natalie. And I'd like to add my thanks to the ICCL for organising what I think has been a really fantastic and really interesting day. I should start by saying I am not a lawyer. I have no legal training whatsoever. So when I'm going to comment a little bit on law, so I just want to sort of emphasize that I am doing it as an outsider, and I'm sure that there may be lots of flaws, perhaps, as many of you are lawyers and legal scholars, in perhaps the technicality of what I'm saying. But I suppose as someone who works in an English department, I'm interested in narrative, and I'm interested in language, and I'm interested in how language is used to put together a narrative and a story. And what I want to talk about today is the voice of women in abortion campaigns. And Louisa set it up very nicely for me by talking about how we need to put women back into the frame when we talk about abortion. And I think particularly when we look at the case of Ireland, part of the problem around the issue of abortion in Ireland is that I think for much of its history, since the Eighth Amendment was inserted into the Irish Constitution in 1983, the voices of women have been largely absent. And I think one of the reasons why we are, in my more optimistic days, I like to think of as on the cusp of repealing the Eighth Amendment, although some days I'm not quite so sure. If I look at what's going on, when I hear Ronan Mullen's comments today at the Eighth Committee, I do begin to despair. But let's maybe take the more optimistic narrative for this afternoon. I think it is the voices of women that have begun to be reinserted. Women, I think, have inserted themselves in many ways into the debate, and that has been, I would argue, one of the, if not the key thing that has shifted forward the debate. And that's a little bit about what I want to talk about today. So you've got the Eighth Amendment. That's just to say this is when a lot of people, we throw around the term Eighth Amendment, Article 43.3 of the Irish Constitution. And opinion polls actually do show that a lot of people actually don't know what the Eighth Amendment is. So anytime I talk about it, I do think it's important to say what it is. It is 43 words inserted by a 2/3 majority into the Constitution in 1983, following a bitterly divisive referendum campaign that was described at the time by the Irish Times in a historical reference to Ireland's, the partitioning of Ireland North and South, as the second partitioning of Ireland. So divisive was the debate at the time. And it says, the state acknowledges the right to life of the unborn and with due regard to the equal right to life of the mother, guarantees in its laws to respect and as far as practicable by its laws to defend and vindicate that right. You'll notice, as Fiona's already pointed out this morning, the use of the word mother. And I'll talk in a few minutes, this is not unique in the Irish Constitution. The word mother and woman is used interchangeably in the Irish Constitution. It is, as Professor Ivana Bacik has written, a uniquely misogynistic article, in that it expressly sets up the right to life of both the pregnant woman and the fetus that she carries in conflict, anticipating that a time would come when someone would have to decide between them. And that is effectively what happened 9 years later in the infamous X case involving a 14-year-old rape victim who attempted to travel abroad to access an abortion in England. Following a High Court decision and then a Supreme Court decision, it was later decided that she was entitled to an abortion, but only because her life was at risk. It emerged that so traumatized was she by what had happened to her, not least the role that the Irish state had played in that, that she became suicidal. And it was only because she was suicidal, it was interpreted by the Supreme Court that she had the right to an abortion. And I think until 9 years later, until that 1992 X case, for the most part, the debate in Ireland had largely been around abortion. As was pointed out this morning, the word abortion wasn't even really used. In 1982, 1983, the term that was used was the substantive issue. That's what everybody talked about as abortion. Nobody ever really talked about abortion. The word was never really used. And it didn't really, I think, kind of feature for a lot of us. I mean, I grew up in the 80s in the aftermath of that. And I was just talking to some friends of mine recently. And I think the first time I actually really thought about abortion was when I saw the film Dirty Dancing. I don't know if anyone saw that, but that, I think, for many people of my generation, it was the first time that we really thought about abortion. Again, the word abortion is never really used in this film, but we all know something's happened. We think she's pregnant and she doesn't want to be. And this is kind of how the story unfolds. But nobody ever really thought that that was the same thing as what was going on in terms of the 83 amendments. So it was always sort of cast behind this kind of veil of secrecy. And along with the secrecy, of course, was the idea of shame, that it was never something that you could speak out loud. Two very brave women in the debate in 82, 83, the campaigner Ruth Riddick and the journalist Mary Holland did come forward and talk about their own abortions, but they did so in very, very hostile circumstances. Mary Holland, in particular, was routinely denounced around the country by both priests and politicians. And somebody told me recently that she was speaking in Liberty Hall in Dublin, which is a union hall in Dublin, about as part of the anti-amendment campaign opposing the Eighth Amendment, and she had to leave early to go to her daughter's birthday party, and the anti-abortion activists in the room started screaming at her, "What about the birthday of the child you aborted?" And this was what followed Mary Holland around for decades. And needless to say, in the sort of hatred and vitriolic kind of tone of the debate, that nobody talked about abortion, nobody talked about their experience. That, however, I think did change in 1992 with, as I mentioned, the X case. It wasn't that we didn't know the names of some women. We did. Mainly, I think there are some women that have kind of punctuated the debate in Ireland around abortion. Sheila Hodgers died very shortly before the Eighth Amendment was introduced into Ireland. She was pregnant and refused cancer treatment. And she died 6 months before the Eighth Amendment was introduced. She was pregnant, she died, and her baby died. Michelle Hart died in 2010, again being pregnant and being refused cancer treatment. We know this. We know Sheila's story because her husband spoke out. Actually, spoke out in the context of the referendum campaign back in 1983. But Sheila's story was ignored. Michelle Hart did again very bravely speak out just before she died, and her story was there, but never never really kind of, I think it was always kind of really kind of pushed to the margins, and it was thought, well, you can always go to England if the situation arose. And then very tragically, 5 years ago, the story of Savita Halappanavar came to the fore, and I think for many people that really is what kind of changed the story. Following Savita Halappanavar, I think many women did begin to speak out. First of all, a very brave group of women associated with a campaign called Termination for Medical Reasons, which are the parents who have experienced a pregnancy with fetal abnormalities. Women like Jeannie MacDonald, Ruth Bowie, Amanda Mellett, and Arlette Lyons published their stories and their photographs in the Irish Times, which is the Irish paper of record. We had the various court cases, often involving anonymous women, Miss X, Miss C, Miss D. But nevertheless, I think their stories did begin to enter into the public realm. The importance of these interventions made by and on behalf of the named women, I don't think can be understated. They are, as the legal scholar Mairead Enright wrote in a particularly powerful intervention in 2011, they are the abortion debate's Antigones. They have consecrated to Irish law not a politics of victimhood, but a difficult, resistant politics of pain, death, and grief. They have done it not as their anonymised counterparts did by going to the law. That's not to say that litigation has not played an important role in the struggle for abortion rights in Ireland. It has. But I think these women in particular who've come forward have done so by insisting on their entitlements, by speaking a language of state responsibility and of citizenship. And I think more recently, again, we have a group of a third group of women who have come forward, who had their abortions for social, economic, or ethical reasons, and they have come forward. Prominent women in public life, like Tara Flynn, the comedian and actress, the journalist Roisin Ingle, who have told their stories. And what is, I think, important about their stories is that when often we've heard stories of women in the Irish abortion debate, they were often kind of women who had been raped, women who were vulnerable in some way, children, young girls in care, women who were in need of abortion for medical reasons. And what was notable, I think, particularly about Tara Flynn and Roisin Ingle, was that they came out and decided and made a case for simply having bodily autonomy, having control over their own lives. They were pregnant and they didn't want to be. And they talked about the hurt and the shame that they felt was imposed upon them by the Irish state, by the fact that they were not cared for in their own country, that they were forced into exile, that they were forced to go abroad as if they were criminals. But in a sense, they were criminals in their own country because the law in Ireland criminalises women who have abortions. And that also adds to the secrecy, but I think most acutely to the shame and to the stigma that goes along with that. There have also been other projects. There's a current photography project called the Exile Project that is photographing women are coming forward, telling their stories and having their photographs published on a website. The Abortion Rights Campaign's submission to the Citizens' Assembly collected the stories of more than 60 women who've had abortions and submitted that to the Citizens' Assembly. And I think in doing so, they've kind of challenged the good abortion, bad abortion dichotomy that we often risk entering into. when women talk about their abortions, because I think of the kind of the stigma that surrounds abortion. And I think they force us to move from this idea of sympathy and empathy to a more dangerous terrain for women, and that is that of identification. We did it, I did it, standing up and owning their decision, not apologizing for it. And I think that has been incredibly powerful in the Irish debate. And I just want to finish just by talking about that idea of women standing up, speaking out, and owning their decision. Because I think it's interesting to think about that in terms of the current climate at the moment. So we've all heard the stories and the allegations around Harvey Weinstein, Kevin Spacey here in Ireland, around the figure of Michael Colgan. And we've seen a number of women come out and tell their stories. And many of them, I think, have done it at enormous personal cost. One of the things that kind of emerges, is beginning to emerge, is also the idea that it's quite clear that none of this is really surprising. I mean, the most surprising thing to a lot of people is that it's kind of taken so long for these stories to come out. And I think one of the reasons for that is that when women speak, and when women speak in public, there is the whole issue about credibility. Pauline Conroy said to me this morning that she's done the math, and effectively it is the ratio to sort of authority when it comes to speaking is 8 women for every 1 man. So before anyone believes one woman, another 7 women have to speak out. Somebody, I think there was a column in The Guardian that recently said, if only 1 woman had spoken out against Harvey Weinstein, would he be in the situation he is now? Probably not. So that when women speak, they risk, they're not seen to have credibility, and they risk their own credibility. So women speaking in public always entails a risk. It is never simply a neutral act. And I referred earlier to using Mairead Enright's phrase about the Irish Antigones. And a lot of the time, the figure of Antigone is seen as someone to kind of embody the kind of liberal individual subject speaking out against the authority of the state. And it's often been invoked in kind of philosophical, political, and legal discourse. She is seen to embody that figure. But I think there is another reading of it, that particularly that kind of feminist legal scholars have looked at, that sees that Antigone is not just an individual liberal subject. She is also a woman. And the question of her gender and her ability to speak is important. Because in the what Antigone's real act of transgression, if you remember in Sophocles' play, is not just that she buried her brother, but that she, through an act of speech, she's given the opportunity to deny her actions at various points, but she refuses to deny her actions. And through an act of speech, she owns her act. And that, in many ways, embodies it is a speech act that embodies her defiance against the state, against Creon. And I think when women choose to speak, I think there are all sorts of kind of questions and negotiations that are involved in those acts of speech. Because first of all, the public realm is traditionally and largely seen to be the realm of men. And when women enter into that realm, they are supposed to adopt the language, the performative language of politics, of the law, and to speak not as themselves. Because when they speak of themselves, when they speak of their pain and their hurt, of the things that are done to them by the state, that they are seen to lack credibility. We rarely listen to them. And when we begin to, I think, even complicate that further, the question of gender is certainly important in relation to speaking. But so too is the question of race. And so too is the question of class. Because when we listen to women, even the sort of ideal female subject is still white and middle class and Western. And there's a whole that excludes a whole section of other women, women of colour, working class women, poor women, marginalised women. And we have seen in Ireland, in the abortion debate, that we have seen women the women who often end up in the Irish courts are the women who very often literally have no voice. They are children, they're minors, they're in the care of the state. They don't even have any parents to advocate for them. We've seen the case of Miss Y, who was literally a woman who she did not have the language. She came here as an asylum seeker and did not have the language to speak. So finally, I know in terms of the campaign to repeal the Eighth Amendment, we've been thinking a lot about things that we might say or slogans. And a lot of time, I think, as advocates, we say things like trust women. And I think that's a very good place to begin. But it's also one inherent with a lot of, in which there's a lot of danger. Because we also know that lots of people don't trust women. So I suppose the kind of challenge is to how do we negotiate that, allow women's voices into a public realm in which women's voices are rarely actually respected. Thank you.
Thank you, Sinead, not least for managing to work in both Antigone and Dirty Dancing into a presentation on abortion. The amount of skill that takes should not be underestimated. Thank you very much. That's not to undermine your contribution, Sinead. Thank you. Next, we're going to hear from Les Allamby. And Les is the Chief Commissioner of the Northern Ireland Human Rights Commission since 2014. And the Commission is, as you might know, at the moment challenging the law on abortion in Northern Ireland and on human rights grounds, and that's specifically in respect of the lack of access in cases of fatal fetal anomaly or abnormality. And prior to that, Les was in Dirty Dancing, no. He was the director of the Law Centre. I'm going to let that one go now. He was the director of the Law Centre, which was a legal NGO working in the fields of social security, mental health, asylum and employment. And he's also a former chair of the Committee for the Administration of Justice. So you also have 20 minutes. And sorry for the Dirty Dancing joke.
No. Well, it's funny you should say that. Now, I'll come to it in a second because you got a thumbnail sketch of how human rights is a contested space in Northern Ireland this morning from Claire Johnson. And not just in terms of issues of abortion, LGBTI rights, the rights of same-sex couples, and dealing with the past in a post-conflict society. One of the virtues of being the Chief Commissioner of the Northern Ireland Human Rights Commission is you get called a few things. And recently I was on a live TV debate around the issue of abortion. And I was accused of being a sexual revolutionary, not quite Dirty Dancing, but so I stand before you as a sexual revolutionary. And I should say it came as news to me, my family, most of my friends, and certainly my colleagues as well. So this is a journey into sexual revolution without the Dirty Dancing. But what I want to do is say something about the case that we've been involved in and some of the experience and learning from that case. The law in Northern Ireland, as you heard this morning, has the same effective underpinnings as the law in the rest of Ireland, but effectively without the constitutional overlay. So our legislation is 19th century. It criminalizes women who procure their own miscarriages. You're guilty of a criminal offence, you face up to life imprisonment. Anyone who supports a woman to procure a miscarriage is also guilty of a criminal offence and is liable up to 5 years in prison. We have child destruction legislation, slightly more contemporary, but still now over 70 years old, which creates the criminal offence of child destruction with punishment of up to life imprisonment, again, unless the act is done in good faith for the purpose only of preventing or preserving the life of the mother. So as we heard this morning in El Salvador, the issue is not just criminalization, but the severity of the sentence, the potential severity of the sentence that goes with that. We also have common law. The UK has a common law tradition, judge-made law. A termination is lawful in Northern Ireland, based again on judge-made law and judgments, where again it would preserve the life of the mother, or the continuation of the pregnancy would make a woman a physical or mental wreck, whatever a physical or mental wreck is in practice. And secondly, a more contemporary case which says the continuation of the pregnancy would have caused a risk again to the life of the mother, or would have caused serious and long-term harm to her physical and mental health. And that's a case called the Family Planning Association of Northern Ireland versus the Minister of Health and Social Services and Public Safety. Now, in essence, our law, and it was mentioned earlier by both of our earlier speakers, access to termination in Northern Ireland is lawful, but a woman has to demonstrate effectively her dependence. She can't get or seek a termination based on her autonomy as a free-thinking individual. She has to be a physical or mental wreck. Her life has to be at risk. There must be serious long-term damage to her physical or mental health, none of which is about her autonomy. And we've heard a number of examples today about the kind of war of attrition that has gone on between those characterized as pro-life and those characterized as pro-choice. Northern Ireland is no different. The publication of even guidance to try and allow clinicians to make decisions on this issue has been legally disputed in a number of court cases that have taken almost 10 years. Finally, the Department of Health issued guidance in Northern Ireland in March 2016, and the guidance is as clear as mud, and I quote, "It's for a medical practitioner to assess on a case-by-case basis, using their professional judgment as to whether the individual woman's clinical circumstances meet the grounds for termination of pregnancy in Northern Ireland." So it's a clinical choice. Health and social care professionals must balance the need for confidentiality of patients with the obligation to report unlawful terminations of pregnancy to the police and the need to protect others from the risk of serious harm. So both of those are left to clinical judgment. We have other criminal law that says if you don't report a criminal offence, then that itself is an offence punishable again by a significant term of imprisonment. So, of course, the reality is that lack of clarity, that leaving it to individual judgment in the context where you could face life imprisonment for failing to make the right particular judgment, means it's much easier to export the problem to Britain than it is to make a decision locally. And Claire mentioned that there were 16 terminations in Northern Ireland in 2015-16. There are something like 700 to 800 women a year who travel across to Britain to seek an abortion, and until recently to pay for that, and it very much is a class issue in Northern Ireland. The FPA used to estimate that was an underestimate. It used to be something like somewhere nearer 2,000 women a year. The position has changed somewhat by the access to pills through Women on the Web and other organisations. Women on the Web have published data that suggests that 3 times the number of women are now seeking advice through their services in Northern Ireland than did 6 years ago. So how people deal with the issue has changed. the kind of numbers that are dealing with the issue are very significant in the context of a small island, or a small part, rather, of an island. The second thing I want to look at, and it came up this morning, and an interesting debate about, well, how valuable or otherwise are treaty monitoring bodies. I have to say, from a position of somebody who heads a national human rights institution, they are actually very significant. We couldn't have taken the case that we took without the international standards and without the comments from committees on the UK's treaty monitoring and the things that the UK have signed up to. So the CEDAW committee, for example, has said the United Kingdom should expedite the amendment of anti-abortion law in Northern Ireland with a view to decriminalising abortion in 2013. The ISESCA committee in 2016 said the committee is concerned that termination of pregnancy is still criminalised in all circumstances, except where the life of the woman is in danger, which could lead to unsafe abortions and disproportionately affect women from low-income families who cannot travel to the other parts of the United Kingdom. The CRC committee has said that we should decriminalise abortion in Northern Ireland in all circumstances, review its legislation with a view to ensuring girls' access to safe abortion and post-abortion care services, and the views of the child should always be heard and respected in abortion decisions. The ICCPR committee have said the state party should, as a matter of priority, amend its legislation on abortion in Northern Ireland with a view to providing for additional exceptions to the legal ban on abortion, including in cases of rape, incest, and fatal fetal abnormality, and the state party should also ensure access to information on abortion, contraception, and sexual and reproductive health. More recently, and clearly more contentiously, and I will come back to this, the UNCRPD committee said, the committee is concerned about perceptions in society stigmatizing persons with disabilities, living a life of less value, and the termination of pregnancy at any stage on the basis of fetal impairment. The committee recommends that the state party changes abortion law accordingly. Women's rights to reproductive and sexual autonomy should be respected without legalizing selective abortions on grounds of fetus deficiency. I have to say that proved extremely unhelpful to us. It muddied the waters in the case that I'm about to describe, and it was seized on by the Attorney General for Northern Ireland, who opposed the Commission's case vehemently throughout the process. It was also used because UNCRPD is a treaty that's been incorporated through membership of the European Union, and therefore the argument was that the CRPD committee's comments had greater weight than any of the other treaty comments. It was asked this morning where the UNCRPD committee was coming from. I'm almost certain, because having looked at some of the other work that they've done in other issues and having looked at the rest of the report, which was very positive about issues of disability and disability rights and non-discrimination, they start and perhaps unfortunately end at one level from the idea that equality is the only game in town, and therefore that's the issue. So we need to have a debate about the nuances of these issues, because effectively, I suspect that was a comment about the UK's laws, not about the law in Northern Ireland, but it had an impact that clearly wasn't intended, and therefore there is a need on the international stage to have a discussion with the CRPD committee about the importance of non-discrimination against some of the realities of what they say and how that will be used in practice. You were given two examples this morning about how this is still a very real issue in Northern Ireland. In 2016, a woman who aborted her fetus at home was reported to the police by a flatmate, was prosecuted and received a 3-month prison sentence that was suspended for 2 years. Currently, a mother who obtained abortion pills for her 15-year-old pregnant daughter was reported to the police by her doctor. Again, if you go back to the guidelines, the issue again of medical confidentiality, which is part of this case, she's being prosecuted, and that decision to prosecute is being challenged legally. The Commission has put in its own written legal submission to support the applicant, and that case has been adjourned pending our own Supreme Court case. So what's our own Commission legal challenge? Well, very briefly, The Commission's challenge is the failure to provide access to terminations in cases of fatal fetal abnormality, serious malformation of the fetus, and for victims of sex crimes is contrary to the European Convention of Human Rights. From the Commission's point of view, we have to base the challenge on what the international standards say and what UN treaty bodies have said in terms of general comments and concluding observations. Article 3 is freedom from torture, inhuman and degrading treatment. Article 8 is the right to private and family life, which is a qualified right. It's not an absolute right. And Article 14 is freedom from discrimination, which has to be read with Article 8. The challenge also encompassed the common law position on the right to the life of the woman and the fetus. And I'll say something about what the High Court had to say because it's particularly interesting in terms of the constitutional position in the rest of Ireland. And also our legal standing to take a case without a victim. So did we have the power to take this case in the first place? We won in the High Court based on Article 8 only. The challenge failed on the grounds of Article 3 and Article 14. It was held we didn't meet the threshold of inhuman and degrading treatment. The Commission's standing to take the case was upheld, and the common law right of the question of the common law right of the fetus was addressed as well. And what the High Court said was, while the fetus has some statutory protections, the fetus has no freestanding right. Any right that the fetus has is inextricably linked to the right of the woman. And that is the common law position in the rest of the UK. And what the High Court said is that common law position is no different in Northern Ireland. Now, that was not disturbed by the Court of Appeal. Whether the Supreme Court will say anything on that issue remains to be seen. All of the issues were appealed either by ourselves or by the Attorney General and the Department of Justice to the Court of Appeal. We lost at the Court of Appeal. Article 8 was said to be engaged, the right to family and private life. So the issue of a woman's right to personal and bodily autonomy was engaged. But as a qualified right, in a set of very conservative judgments, the three judges, for a variety of different reasons, felt that this matter should be left to the Northern Ireland Assembly. We appealed to the Supreme Court. The case was heard 2 weeks ago, over 3 days. There were a large number of interveners. In fact, the greatest number of people intervened ever in a case before either the Supreme Court or its predecessor, the House of Lords. And I want to pay tribute to a number of those people who intervened because their organizations are here today. They were extremely valuable and useful to us. So the Center for Reproductive Rights, the United Nations Working Group on the issue of discrimination against women in law and practice put in written and in some cases oral submissions. There was a cast of thousands, the Humanists UK, JR76, the legal representatives of the mother being prosecuted, Sarah Hewitt. We've heard about a number of brave women elsewhere in Ireland, a very brave woman who suffered a fatal fetal abnormality and then went very public when she discovered she had to travel to Britain for an abortion. Amnesty International, Christian Action and Research in Education, ADF International UK, Professor Patricia Carey, a clinician based here in Dublin, the Family Planning Association, British Pregnancy Advisory Service, Abortion Support Network, Birthrights and the Royal College of Midwives, the Bishops of the Roman Catholic Diocese in Northern Ireland, the Society for the Protection of the Unborn Child, and finally, Equality and Human Rights Commission, but on the question of standing only. Now, judgment in this case is reserved and is being awaited. Candidly, the only thing I can tell you is I'm convinced it will not be either 7-0, either in our favour or 7-0 against us. I'm almost certain that there will be a divided Supreme Court on the issue. I hope, in some ways, for my Commission's sake, that we win, because if not, opprobrium will come, be heaped on from on high politically on the Commission. But that's effectively, and being sanguine about this, we went into this case with our eyes open. So what is the learning for this in terms of some of the wonderful work being done elsewhere? First, I think it's the kind of work that a national human rights institution should do. Under UN Paris principles, national human rights institutions have to recognize the need for pluralism. And from my own experience as the Chief Commissioner, it's what I call the art of the possible. And I have resolutely, in my previous commission, because we've just changed our commission almost entirely apart from me, we're resolutely pluralist on a number of issues. But we started from the position of this is a human rights issue. So we didn't have a debate about whether people were pro-choice or pro-life or somewhere in between on that continuum. We started and we remain with the position that this is a human rights issue. What does human rights standards say? And that's the basis on which we take the case. International treaty monitoring work is really vital and important to us, and therefore the work that's been done elsewhere and the influences that people have brought to bear from NGO communities, etc., has been really useful and vital to us. The legal action provided a fillip for a wider public debate and reform in Northern Ireland. I don't apologise for that. It's not the basis we took it. It was a human rights issue, but we knew that it would stimulate what was already out there. And frankly, at each stage of the court case, it's yet again thrown the issue into sharp relief. And it's meant a number of things have happened that I think the Commission is frankly only one part of a much wider picture. There was an expectation that we were going to win the case at the Court of Appeal. The Department of Justice thought we were going to win. And it's no coincidence that on the day of the judgment was the day that the Parliament in Westminster announced that for the first time women travelling from Northern Ireland to Britain would be able to access treatment for free instead of paying for that treatment. The day before the Supreme Court case, the guidelines about how that would happen in practice, again, were published. They were more liberal than people expected. It allowed, on a means-tested basis, women to have both free accommodation and free travel if they met certain economic circumstances. So low-income women, that became an issue, the kind of the news story. So somewhere in the Department of Equalities in Britain, the news management team is looking at our case very carefully. These things don't happen as a coincidence. The other thing then, I think, is what's happened in Northern Ireland. We've had attempts to amend the Justice Bill without success in the Assembly. The issue was attempted to be kicked into touch by setting up a working group to look at fatal fetal abnormality only. It was revealed during the Supreme Court case that that group of individuals who've never published the report, it's with the Minister of Health and the Minister for Justice, and the Assembly has fallen. But it was revealed, partly to bolster the argument that there was something happening in Northern Ireland, that the recommendation is for some reform in fatal fetal abnormality. You have to prepare yourself for a backlash. We have a Freedom of Information Act. Everything I've committed ever in an email or anything else on abortion has been sought. As luck would have it, I am a fairly temperate individual. I have what's called the pause principle. I reply to everybody's emails that come into me, positive or otherwise, but I always do it having drawn breath before I do so. So that's proven to be not great for those who wanted to see something intemperate said by me publicly. But, and I think this is kind of interesting, we have tried to also open some channels of communication. We've had protests outside of our building. We had the Evangelical Alliance holding a prayer vigil one night on a very cold winter's evening a year ago. We invited them in to the building. We said, if you want to have your prayer vigil in the warm rather than the cold, and we'll give you tea and coffee, and we will discuss what your work is and entails, and we'll tell you about ours. Now, you might feel whether that's a good or a bad thing. I take the view, in a much wider context of Northern Ireland, I will go and talk to anybody about human rights issues wherever they come from. I take the view, in a Northern Irish context, there's little point in just talking to people who agree with you. You have to talk to people who don't. And you have to start from where people are and try and draw them across. I'm not going to try and pretend I've persuaded, frankly, on many of the issues, whether it's talking to loyalist paramilitaries through to talking to pro-life organizations, that much has changed as a result of those conversations. But I hope that some seeds will have been left by way of a legacy for those who come after me as a chief commissioner. So finally, I think in terms of learning, I've been involved in strategic litigation as part of a much wider set of issues all of my working life. You never put all your eggs in one basket, and strategic litigation is just one way of dealing with issues. And so the multifaceted kind of work that had been done by people in this room, whether you come at this from a lawyer, whether you come at this from the position of an activist or some other position, all of that work is really important. And when we look at where public opinion has moved in Northern Ireland, at least in terms of the issues in our case, the pace of change may seem glacial, but it is actually changing in a positive direction. And a recent Life and Times survey showed that 81% of the population agreed that abortion should be legally available in cases of rape and incest, and 3/4 agreed in cases of fatal fetal abnormality and serious malformation of the fetus. So to end on a positive note, public debate is moving slowly but surely in a more positive direction in Northern Ireland. And I think that much of the work that's been done by people in this room has helped to create that climate to move people into a much more positive space on social, liberal and moral issues in Northern Ireland. Thank you.
Thank you very much, Les. We have a period of about 15 minutes during which we can take questions. So if you have questions, now would be the time to raise your hands for any of our speakers. And I think, Frances, also you're going to partake, perhaps.
Right.
Thank you. Yeah, there's one just at the back here. Thanks.
Yeah, hi. I'm Irish Indian. I have just finished a PhD on rights in UCC. I've been living here 10 years. I wanted, and thank you for all I've been hearing since morning, and I'm very grateful to be here today. And I thought I've been in the wrong women's rights organizations before here. What I am coming for, I had an abortion 2 years back, 2.5, 3 years back. I had to cross the sea. I went to Liverpool. The element, Sinead, you were talking about a few things. The one thing that was absent probably was the element of surprise for somebody like me who comes from India where abortion is legal. And for me to realize that, oh shit, I can't, and I could not speak, I could not talk to the GP or I go anywhere. So in the 7th week when I found out I was pregnant, I waited for a couple of more weeks to think about it because, I have a family. I have a 20-year-old daughter and a 13-year-old son, and a husband who's very supportive. But we were still thinking, should we not, what? And in the meantime, it was 10 weeks or 11 weeks, I don't remember. So I did go to Liverpool. And to my surprise, I found that I was carrying a dead fetus with a growing sac. So I was pregnant by all means, by technical means. So I was throwing up, I had everything, but I would have probably ended up with septicemia, what Savita did end up with. So the doctors in Liverpool were fantastic. They gave me all, care and everything. But sometimes I was traumatized by that whole thing, that I could not go over here. So the way I don't have a problem sharing things. I speak in a lot of conferences. Anyway, I write poetry. It's in my poetry. The problem was not that it was traumatizing for me, not the element of decision that I could not take a decision for myself. And I was not in a space where it was safe. All of that was surprising, as well as I don't know how to describe it, because in 1997 I had one abortion in India and I didn't think about it a second time. But here it was quite a challenge, and which is why I don't mind speaking about it. I don't know the law very well still, but the whole thing about agency is so much more important. So this is the first time I really heard something which was very, the way I think, there are other people who think like that. Thanks for that.
I don't know if anybody wants to respond to that on the panel. Firstly, thank you very much for your intervention.
Yes, thank you.
That's the first thing I would say. You've described it as a challenge, and I think that's an underestimation. But certainly what you're saying does speak to a lot of what the speakers have been talking about today in terms of restrictions, in terms of the creeping nature of those restrictions. I mean, we're in a situation where we don't even have the legal rights that have been established elsewhere, as you've just demonstrated. But all of these issues around agency and the kinds of issues we've been addressing today, I think are absolutely crucial, and I think it is really good that we have this forum to discuss them in. But I don't know if anybody wants to say something more, particular about that.
Firstly, this panel was fascinating, and I wanted to thank the organisers enormously for having me participate here. And it's inspiring to hear the different people who are involved from different regions and countries and in Ireland. There are two things I'd like to say. Firstly, I think it's come out really very clearly from almost all participants. Women's agency is what needs to be re-emphasised. And the exceptional case exceptions are not enough. They're not nearly enough. In fact, I think that they're doing us harm. They're doing harm to the central importance of women's agency, because they're not to do with women's agency. They are impossible to apply. They're causing not only delays, but in many cases it's an illusion. How many women find it easy to prove rape? Rape is it's the most unreported crime there is. The fatal impairment, we've heard how impossible it is, and looked at the tragic cases where doctors have refused to say there's a fatal impairment, and it's ruined women's lives. So I think that should not be a distraction. And the only other thing I want to say, and I say it really, I'm surprised at myself as well, that there is an elephant in the room that's hardly been mentioned, and that is religion and the church and what you can expect. And there's going to be a referendum, and don't underestimate the church in Eastern Europe and in Latin America and in Russia. And not only the church, in Muslim countries where one would not have expected this approach, because there is not such a rigid doctrinaire and approach of dogma to abortion under Islam, you're finding some of the same phenomena. So I think that is something that we have to think about. And I would say that the weaknesses, the contradictions in the position taken by the church should be exposed. And one of the ways of doing it is showing that the church has been soundly, very strongly opposed to contraception, not only to abortion. And that makes one ask, exactly what is the church opposing or protecting? Is it really the life of the unborn, even before there has been conception in contraception? And I think also point out that the church is supposed to be a haven for the poor, and the church is targeting poor women in its doctrine on preventing access to abortion. So I think it has to be very carefully worded and formulated so as not to alienate some of the population, that maybe you have to handle it more carefully. But I think that it is an elephant in the room that we've almost ignored in our discussions.
I just want to say thank you for your contribution and for telling your story, because I think it's an important thing to do, but it's not always an easy thing to do. So thank you. And your point about surprise, I think, is very well made, and I think that kind of feeds into another way in which women's autonomy is denied. They're denied information. They're denied knowledge about the law, knowledge about their own bodies, and knowledge, I think, is very important in terms of how we become autonomous individuals, how we make those decisions. Because in order to make the right decision, we need the knowledge to do that. And, that there are all sorts of obstacles. You said that you're Indian Irish, that part of our Irish law around abortion is that it assumes two things. It assumes, one, that you have the means to travel, but also it assumes that you simply have the ability to travel, that you have the visa, that you have the passport, that you can jump on the plane. And again, that is, I think, part of that idea of the kind of white, liberal, middle-class subject that, that often when we do talk about women's experience is centred in the debate, but it ignores the difficulties and complications that women who do not fit into that very sort of neat category experience, and that experience is whatever about the experience of women who have abortions, that experience is kind of negated and is incredibly marginalised even within the kind of discussion. So thank you for your contribution.
Does anyone else from the panel want to say
I
anything?
just want to say very briefly,
Yeah.
thank you for what you had to say. One of the things I think I've garnered in the last few years is the culture of silence around the issue has been broken in both parts of Ireland. That isn't to take away from the kind of work that's been done by activists, etc. But in the last 2 or 3 years, I'm struck by the number of women who've talked about their personal experiences or talked about, and at great risk sometimes to their professional lives, about what's going on in terms of this as a professional clinician, in a way that you wouldn't have heard even 5 years ago, women talking about this issue. And I think that's quite a significant change certainly in Northern Ireland, about the culture of women not being silenced and going way beyond those who deal with this as a political issue to those who are saying, this is my experience and I'm prepared to talk about it in a way that's very brave and is very welcome.
I think we have some more questions. There's one here and one here.
Hi. So I'm from a medical background, and I suppose I'd view everything through particularly abortion through a medical lens. And we were, again, just thinking about the campaign, about messaging, about information. And I think it's apparent, we were doing some research on the Citizens' Assembly of the submissions, of Irish citizens on their thoughts on abortion, kind of more about their concerns that weren't directly addressed, so it would be things on sexual health, etc. And it became apparent in the course of this analysis of 74 responses that people weren't really using the language of human rights, and they were indirectly talking about it, women's choices and bodies and equal access. But people, I think, don't really understand what a right is. I think it's something we hear all the time, but I wonder, is there a way, do you think, of communicating better to, say, the layperson what a human right means, what it means when a UN committee makes a comment and those impacts? Thank you.
Just before I go to the panel, we might take the second question and deal with them both, perhaps.
Hey, Eva.
Thank you.
My question sort of lines up with what you were talking about now in terms of language. In South Africa, we have 11 official languages. And in most parts, you have the law is explained in English, because I'm assuming it's easier to talk about it in English. So you find that in most situations, I'm Zulu. So when it is time to go out into communities and to talk to them about rights, about abortions, it becomes an extra layer or barrier to actually getting the information across, because you still have to first translate what the law says in a language that someone will understand. So now when we're looking back again to women in rural areas, I know, for instance, that when I was taught in primary school, I was taught English in Zulu, if that even makes sense. So you are taught the English in your own language first, before it actually becomes English. So in a situation like that, where most people do not have the opportunity to get the basics of English, trying to explain what abortion is, what right is, what, finding someone. For me, it's easier because I know the root words of those particular situations. So if I had to explain to a Zulu speaker what abortion is, I would try in some words without using because the vernac sometimes is crude. For instance, abortion in isiZulu is ukipisisu. So ukipisisu is literally removing the womb. So automatically, the minute you start talking about abortion to a Zulu person, you are saying, umuyo hambi ukipisisu. Already, the connotations for that is something that people do not want to talk about. So I don't know whether it's a question or a comment, or I just don't know how then we move forward to say in English certain words, even though they have the stigma of abortion. But the minute I take abortion to ukipisisu, already I've entered into another realm that I don't know how well to maneuver. Thank you.
Okay, thanks. Just in respect to that first question, I don't know if anyone would like to start just in relation to how do we educate around rights, or how do we communicate around that concept?
It's one of the least talked about aspects of the international human rights system. There is actually an obligation on states to educate to human rights, and parental preference, religious or cultural, cannot derogate from the minimal obligation of states to educate to human rights, and it's been very neglected within the UN system and by states. There are very few states that have this obligation in their syllabus. Spain had it, as a matter of fact, and then changed it and allowed parents to choose between constitutional ethics in the children's syllabus and religion. So they just moved back on it a couple of years ago. So we critiqued that when we went on a country visit to Spain. So it's very important about language. We did talk about whether we should be using the word abortion or termination of pregnancy. And it might be that in some languages one has to use alternative descriptions to make sure that the correct message that's being transferred. But it is part of human rights education, and we should be all fighting for a kit in languages with human rights and women's human rights.
Just to something that chimes with that, in fact, in an Irish context, is that the current legislation providing for abortion in certain contexts uses the phrase termination of pregnancy, but that has been interpreted in the guidelines as meaning post-viability, as meaning delivery. So actually language is not just important in terms of, I'm sorry, I'm obviously addressing this from a legal perspective almost entirely. It has much wider implications. But certainly if you're a person seeking a termination of pregnancy under an abortion under the Act, and you in fact are afforded the opportunity to have a termination of pregnancy beyond a certain point, it will actually, under the Irish guidelines, result in a delivery.
Can I make a quick point on the rights discourse, and a positive, I suppose, indication of Northern Ireland, wider than issues of abortion. But there have been a number of funders through Community Foundation for Northern Ireland who have offered grants to community organisations to do work around social justice and rights, where they've encouraged and done some quite innovative work on reframing what are community-based issues through a rights-based framework. We lack a Bill of Rights for Northern Ireland. It's part of the Belfast Agreement, but there was an enormous amount of work done by NGOs, by predecessor commission, to build up the idea of what a Bill of Rights might be and look like. There is a much greater rights discourse in Northern Ireland. I don't always recognise it in terms of international standards and treaty monitoring about how rights are asserted, but I take it as a very positive change between when my working life started in the 1980s, when a rights discourse was pretty much a cloistered discussion between lawyers and academics, and now where there really is a rights-based discourse, even if some of that rights-based discourse is pretty much of a false consciousness, the fact that people talk about my rights or our rights, I think is actually a very positive issue. So there are ways in which, through community-based kind of approaches, you can begin to get people framing what are their local issues, or whatever they are, environmental issues, issues of women's rights, in a rights-based framework. It is possible to do that in the most difficult of circumstances.
Louise, I think, sorry, I had
Oh,
interrupted
no, that's
you.
fine. On the rights question, so I would say that we have two different ways of thinking about it. So one is, and this is based on, focus groups and communication studies, that if we bring a big case, our press release almost never, doesn't usually have a quotation that's about rights. It usually has a quotation that's about decency or fairness or something like that. And part of that is because, and again, this goes to certain almost like triggers that people sometimes, if they hear, well, this is a violation of rights, it sounds conclusive, and it doesn't necessarily talk to how people talk, say, at a dinner table or whatever. So fairness, more people will hear fairness than will always hear rights. So we have that frame. And then we also spend a lot of time with know your rights. Because it's also really important that when there's a right, like when the cops pull you over, that you know what you can say no to, and that you know you can call a lawyer, and what you can do, and that you know that abortion is legal until this point. And that, I hear what you're saying too, how important it is to have a discourse about rights, and then also how important it is to try to move people to care about your issues when you're trying to sort of open up spaces in certain sense. Your comment about Zulu, I just want to say that's one of the critical reasons why it's so important that our coalitions and our work be diverse, so that we can hear that people from communities or from all the different communities are reflected, so that we actually bring the richness of the culture and figure out how we talk to different, how we hear different people and how we effectively communicate.
We have run out of time. So I just want to say thank you very much to this panel for all of your contributions. Also, I suppose just to add my voice to thank the Irish Council for Civil Liberties, who, by the way, are on a daily level engaged in exactly that exercise of informing us all about our rights in a myriad of ways. So thank you to them. And I don't know, Liam, if you want to say anything by way of finishing up, or? Great, Stefanie will do that. Great, hi.
So, can you hear me? Yeah, you can hear me. So I also want to thank all the wonderful speakers of today for this very rich conversation. I particularly enjoyed learning more about the Irish campaign and the Northern Irish developments that I knew very little about. I am Stefania Kapronczai, and I'm the co-chair of the International Network of Civil Liberties Organizations, one of the co-organizers with ICCL of today's event. And INCLO has 13 local NGOs who bring local experiences to the table. Many of the speakers who you heard today represent one of those organizations. And we coordinate our strategies in order to influence the state of global human rights. And this is what we were attempting to do today as well, to bring these local experiences, to highlight the common themes, and also strategize and think about what are the ways to advance reproductive rights in this case. And we are also supporting our members who are at a critical juncture, and now this is the Irish community, really, with the Repeal the Eighth campaign, not only the ICCL. What we could see really throughout the day as a recurring theme is that there's a general pushback to human rights, and it affects the human rights institutions as well, but also human rights defenders in a very profound way in their everyday work. We heard reiterating those scientific arguments that we, I think, in the room are very familiar with, that very much support our stance on sexual and reproductive rights and reproductive justice. We heard that despite those scientific arguments, and despite that there are some very good legislations also on a paper, there is a backlash. And the backlash can come in the face of legislation, but also in other ways and forms. And we also learned that if there's a legislation, it is important, but good law is not the end of the story. We heard many stories about access, problems with access to information, both on the sides of the women, but both on the other side, on the side of the doctors that impede women to access very much needed services. So we heard from South Africa that oftentimes it's not even known where local facilities can be found in the country, and that affects women's access to much needed services. But we also heard from Colombia that doctors are saying that they have very little knowledge about contraceptions. So how could they advise women about that? And we also heard from the US that there's an issue about accessing the facilities themselves. And counseling being another ways of restricting women's access to abortion services. Another important theme that I could identify in today's discussion regards the abortion pill, the medical abortion, that really speaks to the question whether women's health and life is in the center of the debate or not. Because in many jurisdictions we see that medical abortion is not available despite the very clear medical evidence supporting the availability. We also heard and we talked quite a lot about how these reproductive rights are entangled with other rights, social and economic rights, especially we talked about poverty and the restrictions disproportionately affecting poor women. The restrictions disproportionately affecting young girls and indigenous communities. We heard a very compelling story from Egypt. And then we discussed also strategies and activities, how to counter it. One of them being litigation in India, advocacy, and quite interesting story from Argentina about mobilization and how it succeeded and how it is bringing forward social change. And this is also something that we are currently witnessing in Ireland. And then we also heard about legislation being a very important tool. We heard an example from the UK. And then towards the end of the day, we started to talk about the need for education. And I could identify a couple of needs that the sexual and reproductive rights movement are in very much need to continue working with. And one of them centers around narrative. We talked about whether language, the rights language is a useful one, and the need to put women and people in the center of our discussions. And I would like to highlight this because one of the reasons why there is a pushback, or one of the driving forces of the pushback, is that there are populist governments in power in many of our countries. And these populist governments are using their narrative to convince people, and they are relying on the majority of the people. So it is crucial to be able to reach wider audiences and influence a wider constituency when we are trying to hold back those pushbacks. And I also identified the need to organize coalitions. And we talked quite a lot about the disability rights movement in this room. And I think a way forward is to really invite them to the table. And whenever whoever is organizing the next conference, invite disability rights groups to the room, because I very much agree with all of our speakers that the origin of the disability rights movement is also a human right. They are coming from the human rights movement, and I'm pretty sure that the intentions are very similar, but there is a need to reconcile and not to not to make the debate even more strange. So I very much see a need of coalition building and strengthening the relationship within the human rights movement, and especially in this case with the disability rights movement. And then finally, I'd like to highlight one encouraging point that many of our speakers came back to, and it's about being ambitious. It's about not only attacking the backlash, not only fighting back, but also fighting for advances. Because we could see in the UK example that there might be a legislation passed in 1967, but there is no revision afterwards. So use the opportunities that are there to seek advances and not only to stop the pushback. So with that, I very much want to thank you again to Liam and Liam's team for organizing this event and bringing us all together. And I'm very much looking forward to supporting the brave initiatives that are coming from this room. And I know from Liam that the interventions will be shared with the author's permission on ICCL's website as a starting point for further discussion. And as for INCLO, we will be having a private meeting with INCLO members tomorrow, and we will continue the strategic discussions that we started today. So thank you very much, and enjoy your evening.